So let's talk about performance gaps in the industry. I'd like to hear what you're seeing in terms of performance gaps with legal tech these days.
Yeah, this is probably not going to be as sexy as the answer you want because you're thinking of machine learning, whatever. No, it's productivity and emails and time management.
All right, I'm interested in this.
Yeah, and there are exceptions, but I can't think of many. But most attorneys, you get into a situation where you need to look for an email and you sit down at their desk and watch a general counsel try to find an email and you see how many are in their inbox. It's gross. It's really terrible. And I can relate to the feeling of helplessness of living out of your inbox and just not having control of what you're doing. And you think about the distractions of emails when you have it up all day, right? Ding, ding, everything that hits the top of your box, you want to respond to instantly or do right then and there because it's top of mind, right? I have to do it now or I'll forget about it. It's going to end up 6,000 down. Yeah. And that frankly sucks. That's a terrible way to live your life, right? So
there's a tyranny.
Yeah, I feel like the big technology gap is understanding how to use technology to build a second brain and to have a way to process all of your inputs. And by that, and people don't believe me, I easily get 300 emails a day. My inbox is at zero most of the time. And that's because I'll wake up and I have a process that I follow. Everybody has a process, but a variation of getting things done and some other things. I'll wake up, I'll look at my emails. First 30 minutes of my day is processing my inbox. And I convert things into tasks. I put things on my calendar. I delete them. I delegate them. I have different things that I do. And that's getting them off my immediate brain and into the systems that I work throughout the day to help prioritize and manage my workload. And that's the biggest issue I see is attorneys are so buried by emails and requests that their job becomes reactive and not getting ahead of it for good results. Case in point, discovery, right? You and I both work in the discovery space. I love it. But how many clients come to you and say, I don't have a deadline. I just want to figure out what my documents say so I can get to an effective settlement position. How often does that happen?
I'm waiting for it.
Right. It's not common, but that's something that's very attainable. When you invest in the technology and understand how things work, and you've got the bandwidth because you're not always getting pinged and distracted and you're focused, you can line things up and get ahead of things and effectively mitigate that risk of litigation and downstream time and money spent by getting ahead of things. And that's a great position to operate from.
That's a great tip. I appreciate you sharing that. So I think we have another question. Cool. This is from Peter Bennett. So as an experienced paralegal that works with a bunch of e-discovery and AI firms in my large AmLaw 29 firm, we'd like to do more. Is this something that if not here, you think possibly another firm could have?
I'm not 100% sure what that's asking. So if you work at a big law firm, a lot of big law firms have their own e-discovery program, right? That's a great cost center and kind of a good value for your clients that don't want to bring that on themselves. And a lot of the modern tools that people are using are already leveraging very advanced machine learning, whether it be supervised, unsupervised, whether it be sentiment analysis, whether it be entity extraction or NLP, right? There's a lot of types of machine learning that's going on in modern tools. Yeah, that's 100% something I think that law firms should leverage. I think law firms definitely would benefit from the addition of data scientists, especially and that's happening. I know some of the really big law firms that I talk to do have data scientists on staff that are helping develop and build workflows and models that they can apply towards their clients.
Workshop some of the use cases.
Yeah. Cool example, DLA Piper, one of the biggest, right? I work with their guy in London a lot, and we collaborate and brainstorm on ideas, and they built a really cool tool that clients can hire them to apply their tools to their data and quickly detect if there's cartel activity. Very hyper-specialized thing that's a service that is very in demand by a lot of large companies because you've got to be careful about for privacy reasons, government contracts. Yeah, large law firms definitely benefit from this technology, having expertise at the table. And again, I would caution you against your e-discovery person being the AI expert because generally what you use in e-discovery tools is just a small slice. And you're only using pre-built tools. You're not actually making anything from scratch or programming algorithms from a bespoke perspective.
But that's where a lot of the value lives.
That's where most of the value lives because, again, there's no tool that exists that can predict what kind of AFA I should apply to immigration cases. But I built one, right? And that's a cool thing to be able to do in conjunction with the team because that adds tremendous value, but you can't buy it. It's solving a unique problem your company has by leveraging what's out there that's not built into an e-discovery tool.
That's awesome. I appreciate this perspective. So from Jesse Holmes, how do you pick your AI technologies and why?
The way I think about them is one, from a privacy concern, I want to make sure that any data that's accessible by anyone else is anonymized and our own proprietary data, that it's not leveraged to train models for anyone else, even the company that I'm retaining. So that kind of privacy security is really important. Portability is the other big thing.
Absolutely.
It does me no good if I have to start from scratch every time, right? We built a workflow at Balfour, which I'm really proud of. We have about close to 40 different bespoke models we built for our data. Some are based on construction type documents that we need to find and identify quickly. Some are based on just standard RFPs for construction defect cases, right? Right, because the RFPs are always asking for the same kind of things: owner contracts, change orders, scheduling documents, right down the line. So we've built models literally based on the RP to help you respond quickly and efficiently. We also have proprietary models we built for exclusion, besides like junk and proprietary and privilege and all the things you think about. So when you're able to stack and pack all of that from your library, train them on the data for that particular case, but then park that and bring it into your next similar case, you're 90% there. So that portability and the security concerns are the biggest thing for me. The other thing that people aren't talking about a lot, and this is a big one, is what method of training is the AI model using? And this is going to be more important in generative AI. The term mechanistic interpretability, it's hard to say, but fun to learn about.
I'm going to practice that tonight.
Yeah, so it's how an AI model shows its work, right? And all right, so a big one is RLHF, reinforcement learning by human feedback. And that means there's 100 people in a room that are clicking buttons. I like this output more than that output. Cool. And that's how the model gets to its output. But think about this: a year down the road, a judge says, I need you to show me how you got that answer from your model. What do? Point to the 100 people and be like, some combination of them clicking a button got me there? That's not good enough. But there's other types of mechanistic interpretability, like constitutional AI, where you have a second AI model that acts as like a constitution, your governing principles, and it is what directs the model into giving a type of output. That you can point to, right? The reason it gave this output was because it triggered this rule, and that's why you got this answer. That's much easier to prove in court and satisfy a judge's inquiry. But that's something that, again, e-discovery people aren't even thinking about yet, because this is all very new. All to say, those are the big reasons, right? Portability, security, privacy, and then mechanistic interpretability. How I'm able to see behind the black box.
Oh, I love that.
Yeah.
Oh, folks are learning a ton. I appreciate you sharing that.